Hello everyone, welcome to Greenway Chambers. Adam Castleton's my name. I'm one of the silks here who practice in the area of property law and general commercial law. Tonight's topic is dealing with some recent cases in relation to property law. We have two speakers, Joshua Naxted and Michael Connor. Josh will be speaking first, and the talk is really about a series of cases that have been heard recently in the Supreme Court and the New South Wales Court of Appeal involving a development at Lane Cove, a case in which Joshua and Michael were intimately involved in. And those cases, or series of cases, touched upon a number of important aspects of property law, dealing with things such as indefeasibility of title under the Torrens system, caveats, the concepts of legal tender under sale of land contracts, stays and costs against liquidators. I think, Joshua, you're going to be talking first, aren't you? Mm-hmm. So I'll invite Joshua to come first. It's very informal and interactive, so if you've got any questions, jump in. Each of the speakers would welcome questions so that we can open it up to the floor about various issues that are going to arise as Joshua takes you through the case of LUM developments, or MV developments and LUM. Yeah.
Thanks, Adam. All right. So, as Adam said, if anyone has any questions along the way, please jump in and we will do our best to answer them. As Adam said, this was about the construction of a development in Lane Cove. As many interesting property cases are, it was an off-the-plan type arrangement. Just at the point where the development had been actually completed, the developer went into administration and then into liquidation. And that left a number of purchasers in a kind of limbo situation where they had signed contracts for sale for some of the lots but had not yet completed. In the background were a number of lenders, there were registered mortgagees, there were also lenders who weren't registered and who claimed various forms of equitable interest. In some cases, there were purchasers who were claiming interests over the same lot because there had been a situation where contracts had been signed selling the same lot to two different people. Some of the purchasers had paid and released their deposits to the company for its use in funding the development. And those deposits in those cases were all or almost all of the purchase price under the contracts. And that all came about because the director of the developer had involved his friends and family and had convinced them to help him complete the development by doing this. And a lot of the lenders didn't know about each other either. There were some very unusual forms of payment, which we'll get into in more detail. And there were priority disputes between all of these purchasers and lenders. There were 4 decisions. Oh, I should also say, as Adam said, I acted as counsel in all of these, and Michael was instructing me when he was at M&K. And then after he came to the bar, Nick there? Nick took over for the Court of Appeal case, instructed me in that case. But yeah, there were 4 cases, 4 decisions which were handed down, and the way the proceedings started was that the liquidators issued a letter to the Lums brothers, who were the nephews of the director, Mr. Fong, and had entered into one of these unusual arrangements where they had paid all of the money up front, I think save for about $50,000 each, and had released it, so it had all been spent. And the liquidators issued them with letters saying that they would ignore the contracts and proceed to market their units for sale. And if you have a look at the bundle, which you hopefully all have, you will find a copy, not of the letter issued to the Lums, but if you have a look at page 23 of the handwritten pagination, you will find a copy of a letter written to one of the other purchasers, Erica Yuan. And if you look at the second last paragraph, you'll see there that the solicitors who were acting on behalf of the liquidators said that they would ignore the contract, that's the purchase contract, and market the property for sale after 7 days from the date of the letter. So in the case of the Lums, they had lodged caveats over the title, and the liquidators issued lapsing notices, so they applied to the court to extend the caveats, and that's how the proceedings were kicked off. The liquidators defended the interlocutory application on the basis that that there would be no utility in extending the caveats because the registered mortgagees wouldn't be able to be paid out from all of the other unit sales, and therefore there'd be nothing left. Their equity would have to give way to the registered mortgage holders. But we were able to convince the judge that we just didn't know whether that would ultimately be the case at the point where we had a final hearing and asked for specific performance. So we had the caveats extended, and then the proceedings sort of developed in the usual way. Michael will talk more about the facts in the Lum case, but once that proceeding was concluded, the various lenders were still in dispute because they hadn't had their claims determined yet, and they joined Mr. Antonios, who was another purchaser of another lot in the development as a cross-defendant, and we ended up acting for him and effectively running the same case against the liquidators again. And so we'll get more into the facts about that shortly as well. But that's basically the broad outline of the case. And I think I'll hand over to Michael to talk about the Lum facts for now.
So as Josh said, Mark and his brother were the nephew of the sole director of MV Developments, and Victor Fong had involved all of his family and friends and basically anyone that would release funds to him under a contract for the sale of something that didn't exist yet. So he's in the process of building when he sold some of the lots in a strata plan that didn't exist. But when the Lums released 90-odd% of their purchase price, sods hadn't been turned yet, and there wasn't a strata plan. It just was something in Victor's ambition. So we were approached by the Lums when the company went into administration and, as Josh said, received lapsing notices in respect of their caveats and these letters saying we will ignore your contracts. What was more remarkable about that correspondence, though, is that they also sought to rely on a clause in the contract 33.1, which was a contractual prohibition to caveat.
That's in the bundle as well, by the way.
It is. So, paginated 1 down in the bottom right-hand corner at the front of the bundle. If you look about a fifth of the way down the page, the purchaser shall not lodge a caveat on title of the property prior to completion. And so that
the letter's in there too.
The letter's in there in the bundle as well. If you want to look at how ridiculous the situation was. So in the one breath, they were seeking to rely on the terms of the contract, but then also seeking to ignore the contract. And it was a strange set of affairs. We kicked off proceedings quite quickly, seeking an extension of the operation of the caveat, and we came before Justice Dark. Now, at that stage, we hadn't joined all of the parties that were interested in the proceedings. We'd only joined the liquidators at that point, and we obtained extensions of the operation of the caveat. Then as the proceedings progressed, the liquidators were selling the lots in the development. So there was a lot of cash coming into the company's account, which was then being distributed to the registered mortgagees. There was 3 of those, and they were all paid out during the course of the proceedings. So then we had a much clearer picture of what would be left over based on the sales of the lots yet to be sold and who was fighting over what. And as Josh said, the director had sold some of the lots multiple times to different people and accepted consideration as well. So it wasn't just that they held exchange contracts, but in some cases there was an assertion that 2 purchasers had paid the vast majority or all of the purchase price for the same property. In the Lum case, one of the key issues was whether or not the Lums were defendants or whether or not they were plaintiffs. And what was argued, which will be relevant in terms of costs, is that the Lums were in fact forced to commence these proceedings in order to protect their equitable interests. So in effect, although they had plaintiff written next to their name on the proceedings, they were in effect defendants, and that's relevant when we come to costs. Another thing that Justice Stark held was, and this was a key finding, was that the liquidators acted unreasonably when they were actually administrators issuing lapsing notices in respect of these caveats. Now, administrators aren't supposed to do that, and also issuing these letters. Then the liquidators were ordered to personally pay the Lum's costs in those proceedings. So not the company, the liquidators personally. And we'll talk about more of that issue at the end. So hand over to Josh. He can talk about the next set of proceedings, which was about Antonios.
So this is where it got really colourful, because Mr. Antonios there he is right there. As you can see, he was a professional poker player, and he was a very, very smart guy. And
World Series Poker, he won the tournament.
And he became friends with Mr. Fong because they had a mutual interest in playing poker and would see each other at the casino. Although, and this might be part of why MV Developments ultimately didn't manage to survive, I'm not sure, but Mr. Fong convinced Mr. Antonios, who is referred to as AJ, convinced him that he should buy a property and that it should be in one of Mr. Fong's developments, and ultimately it ended up being in the Lane Cove development. And before the contract had been entered into, Mr. Fong had borrowed about $300,000 from AJ in order to fund his entry into various poker tournaments. According to AJ, Mr. Fong was a very bad poker player, but he unfortunately spent a lot of money on the game. So he'd borrowed about $300,000, and there was correspondence between them about when it could be repaid, and instead of it being repaid, he kept borrowing more money. And then that coincided with him convincing AJ to buy a property, and as part of the deal, he said, why don't you forgive your loans and we'll convert that to equity in the property. So the first, I think, $300,000, or maybe it was $350,000, in this property was formed by the forgiveness of these loans, which had been made personally between AJ and Mr. Fong. Then, because he was a professional poker player, he doesn't deal in money in the same way as perhaps most other people, and tended to carry around very large sums in the form of cash and poker chips in his pocket, including, and when I say large, I mean hundreds of thousands of dollars. And so the balance of the purchase price was paid in a combination of poker chips, cash in brown paper bags, and as to $200,000, there were some electronic funds transfers. But he mostly had his money in what's called a cage account at the casino, which is basically like a bank account, but it's obviously not a bank, but it operates like a bank account, and people who play a lot there can take money in and out either in cash or casino chips.
It has statements,
Mm-hmm.
it has debits and credits, you have an account number, you have a key card, you are required to show ID. It's actually, I think, much more secure than putting your money in a normal bank, but we'll talk about that.
So AJ didn't know anything. He knew a lot about poker, but didn't really know anything about anything else, including, I shouldn't say that. He didn't know anything about how property transactions worked. He didn't know, for example, that he should have a lawyer, and Mr. Fong didn't tell him that he should have a lawyer. So what happened was he was asked to come to Mr. Fong's office with payment in cash or casino chips, and sign a contract, and a lawyer was obtained by one of Mr. Fong's employees recommending his brother-in-law. So this brother-in-law was assigned to AJ as his nominal solicitor on the transaction, and reviewed documents and put together a contract. AJ never met him, but he, as he was sitting in this office for a few hours, that all happened, and ultimately it was signed. And when it was signed, it was obviously a very large document, as anyone who's seen these off-the-plan sale of land contracts will know. And he was about to go to a poker game. So he said, I can't take this huge, big contract with me. And Mr. Fong said, don't worry, we'll keep most of it. You just take the front page of the contract with you, and everything will be fine. And that became a very interesting point in the case, because one of the issues, or maybe the key issue, was what was the document that he in fact had signed on that day. So by this stage, obviously the liquidators were angry because they had lost and had been ordered to personally pay the cost of the lums, and they were much more intractable in terms of the way they approached the litigation on the second occasion. All of the equitable interest holders ultimately conceded, all of the lenders, asserted equitable interest holders who had loaned money to the company conceded priority, and there was a dispute between AJ and another purchaser who claimed she had also purchased the same lot, and there was a dispute between her and another purchaser who claimed they had purchased the same other lot in the development. So all of this was listed for hearing, but ultimately the dispute, because of various agreements between other parties, ended up being between AJ on the one hand and one of these lenders on the other, Tarlee. Tarlee, as I said, had conceded priority, but it effectively ran the company's case and said, you can't prove what contract you signed because you took away the front page, and the document you've put into evidence has just been compiled from what you think was the document you signed. Therefore, you can't prove the contract. Therefore, you can't have specific performance. That was one argument. Another argument that they ran was that that the method of payment was ineffective, and ultimately, I should also mention as well that the liquidators entered into, late in the piece, but before the final hearing, the liquidators entered into a deed with Tarlee and one of the other lenders, which effectively tied their hands and didn't allow them to settle the proceedings against AJ. So they contractually bound themselves in a way that prevented them from settling the proceedings, and that'll be relevant later when we talk about costs. Justice Emmett looked at Tarlee's asserted interest and said it in fact did not have a proprietary interest in the property. He found that the whole of the purchase price had been paid. We put in quotes there, under the contract, because there was no dispute that these sums actually were paid. The dispute was whether or not they were effective payments under the contract. Everyone was ordered to withdraw their caveats, and the company was ordered to transfer the property to AJ, and that in fact then did happen. And the liquidators were again ordered to personally pay AJ's costs because of the way that they had conducted the litigation. So let's just talk about legal tender. So in your bundle, you will find at page 2...
Just hand something out while we're considering these issues.
I should also tell you that AJ was the best witness I have ever had in a case. Because he was a professional poker player, he applied everything that he knew to being a witness and was extremely convincing.
So if you get a question wrong, you have to give it back. And if at the end of the presentation you think that that's not worth anything, you can also give it back.
So,
was this from the trust account or?
Cage account.
Cage account?
Yeah.
So actually, just before we look at page 2, if you just all have a look at page 21, you'll find a letter which had been written by Mr. Fong on company letterhead, confirming that the company had received all of the payments under the contract, so $910,000. Interestingly, this was written the day before most of the payments were made, so that was also an interesting factual issue in the case. But the judge didn't think, he was willing to accept that this had been written with the intention that the payments were actually going to be made and that they were in fact made. So if you just have a look at clause 2.4 on page 2, these are the standard terms. You will see that it says that the purchaser can pay the deposit by cash up to $2,000 or a cheque. And just remembering that the deposit in this case was the entire purchase price, this was the clause which Tarlee said applied, and the argument was that that meant that because cash of more than $2,000 was paid, that was not an effective payment under the contract. Because casino chips were used as payment, that was not an effective payment under the contract, and indeed because electronic funds transfers were used, that was not an effective payment under the contract. So not particularly meritorious arguments from a factual perspective. And what had happened in this case was that Mr. Fong had either directed these payments, he had either said in conversations, can you please bring $200,000 in cash tomorrow, or he obviously had accepted the payments when they were made. And as I said, there was no dispute that the payments had actually been made. So clause 2.4 is interesting because you can see that the purpose behind it is to protect both parties so that they're not burdened by having to deal with large amounts of cash or forms of payment which might be difficult or unwelcome. And it just defines what I suppose is a reasonable way of dealing in a way that can be documented and kept track of. And if you then look at clause 2.5, it talks about what can happen if the deposit is not paid on time, and really it should be read with 2.4. So it talks about a right to terminate. So our argument in response was, well, 2.5 is the answer in terms of what can happen if payment is not made in the way that clause 2.4 says it should be. So there can be a termination of a contract, but in this case there wasn't one. And because the company by its sole director had either asked for or accepted these other forms of payment, that was okay. And as to the loans, our argument was, well, we could rely on the indoor management rule because Mr. Fong was the sole director, and the internal accounting between him and his company was a matter for him. And if he, as the sole director, said to us, I'm going to treat this as equity, we were perfectly entitled to rely on that. And that is exactly I should say, at first instance, the judge kind of glossed over this issue and just said everyone conducted the proceedings as if this was all an acceptable form of payment, and therefore that's the way I'm going to treat it. The Court of Appeal dealt with it more directly and basically accepted AJ's arguments about the payments. So the chips you've just been given can be used if you wish to purchase a property, although it's a good idea for you to get in writing that you're allowed to do it that way or otherwise document it. And now Michael is going to have a bit of a chat with you about priorities.
So as Josh said, there wasn't a large contest with most of the parties in respect of who took priority, and that was a sensible result in the end, although part of the priority dispute with some of the parties only resolved on the first day of the hearing. We had been writing to them for years saying, literally years, saying we will take priority to you because your interest is postponed to ours, for instance, and these issues didn't resolve until very late in the piece. But in terms of the main principles, you might have a legal versus a legal interest. So, for example, to registered mortgages, and in that case, just generally the first in time will prevail, and you can have a look at the Nemo DAT rule for yourself. That's not largely relevant to these proceedings because that was conceded. You can then have a contest between equitable and legal interests, and the timing is important in a sense in that, but in this case I'll just look at an equitable interest first and then a legal interest. Section 42, which Josh will talk about shortly, is the key provision of the Real Property Act in that the inconsistent legal interest which is registered afterwards will extinguish any prior equitable interest. And this was a key issue when considered by the Court of Appeal in respect of whether or not Tarlee, who was the appellant, could even bring the appeal, let alone had any equitable interest following the transfer to Mr. Antonios. Then the most relevant for this discussion is equitable versus equitable interests. So these are considered in terms of equitable interests that are of equal merit and equitable interests that are of unequal merit. Now, timing, again, is very important, but also you have to look at the whole circumstances of the way in which these equitable interests have arisen. Now, a very recent case that Adam actually appeared in is the matter of LTDC Proprietary Limited and Cashflow Finance Australia Proprietary Limited. It's a decision of Dark J, and that involved competing equitable interests, one of which was created after the other. The important part in that case, though, was the equitable interest that was created by the financier to begin with was not protected by a caveat prior to the second equitable interest being created. And one of Dark's key findings in that matter, I'm sure Adam will correct me if I'm wrong, was that the failure to lodge the caveat prior to the second equitable interest being created allowed the registered proprietors to represent to other people that they were able to give that second interest. And that ties into the purposes of caveats, which Josh will talk about as well. So it's worth noting that an equitable interest, although it was created earlier in time, and the presumption would be that that takes priority over a latter equitable interest, can be affected by postponing conduct. And one of those aspects of postponing conduct might be the failure to lodge a caveat on time. So the primary purpose of a caveat, as you know, is to create an injunction, a statutory injunction, to prevent any subsequent dealings being registered on title. It's a very powerful tool. So even if a registered proprietor purports to grant a mortgage which can then be registered on title, a caveat lodged will prevent that from being registered. The secondary purpose of a caveat is to put people on notice of your equitable interest. And that's for anyone who would search the title of a particular property and see, well, there's a caveat, and then they can look further, they can ask for further information of the registered proprietor or the asserted equitable interest holder, and make up their mind as to whether or not they will accept this equitable interest. So in these proceedings, Tarlee accepted that because their equitable interest was created earlier in time, and they failed to lodge a caveat before Mr. Antonios's equitable interest was created, that if Mr. Antonios in fact had an equitable interest, his would take priority to Tarlee's. What they contested was that, as Josh said, there was any equitable interest created at all by virtue of the operation of clause 2.4 of the contract. Now, because of that concession, we thought the case would go one way, but in fact the court found that Tarlee didn't have an equitable interest at all, so that priority issue again fell away. One of the more interesting parts of the case, and we found this out about a week before the hearing, is that Tarlee didn't in fact advance any funds to the company whatsoever. It was a separate third-party company which was by then deregistered. And we managed to get a copy of their bank accounts to show that the 1.5 odd mil that they claimed had never been advanced by the company in the first place. So you can see that in the scope of the merits of this case, taken all the way to the Court of Appeal, it was quite outstanding. So although the primary purpose of a caveat is as an injunction against any further registered dealings, what we suggest is, notwithstanding any contractual clauses prohibiting caveats being lodged on title, you need to have a balancing exercise as to whether or not you caveat. So on the one hand, you caveat and you protect your client's equitable interest, and you also insulate your client from being guilty of any postponing conduct. And on the other, you risk being in breach of a term which might result in, say, nominal damages. So you really have to weigh up those two issues and decide what you're going to do. I'd suggest erring on the side of caution. Lodge a caveat if you have to, and then you can deal with a contractual prohibition afterwards. And a court will look at all of the circumstances in which you lodge that caveat.
So it'll be relevant to the balance of convenience if there's a clause like 33.1, but the court won't look at that and say, well, you can't have your caveat extended because you've agreed not to lodge one.
Yeah, particularly in circumstances like this case where that clause is in order to allow things like strata plans to be registered without the burden of having to go to 50 or 60 odd caveators and having them remove the caveats, lodge the strata plan, and then register them again, or all of those mechanical things. And a court will take that into account.
All right. So while we're on caveats, obviously, as Michael said, they are statutory injunctions, but they don't create interests. They just simply prevent dealings, and as Michael said, they've got that secondary function as well of giving notice. If you look at your bundle, you will find the deed of loan and guarantee at page 3, which Tarlee and the company entered into, and under which it says it advanced $1.5 million. And there are a few interesting things about this. One is, if you look at page 4 of the bundle in the recitals, recital G says the borrower acknowledges that the relationship between the lender and the borrower is simply that of a lender, creditor, and borrower, debtor. And that became one of the points of significance when this was being looked at for this purpose. You'll find the relevant clause on page 11 under the heading Default and Consequences. So clause 7.2 talks about what might happen if there's a default, and A says that, amongst other things, the lender can lodge and maintain a caveat on the titles to the Aurora site. And if you look back at the definitions, Aurora site is defined somewhere. Weirdly not in order of, not really in order, but on page 8, it talks about it being the land comprised in certain folios, and they were the original development lots. So what happened was there were 4 development lots which became consolidated and then split into a strata plan. And then you'll find that there was a guarantee clause as well, and it talks about, in clause 8.1 on page 12, it talks about, quote, secured monies. And that's the only place, I think, in this whole document that the word security is used, or security or a derivative of that word. So the question was, did this, in fact, create a proprietary interest in the land or not? And some of you might know this area, but there's been a development in the law over time where, starting with Troncone, which is a Court of Appeal case in 1994, there was a decision of the court there that said effectively that where there is a right to caveat, it carries with it an implication that it must create a right in the land. Then, more recently, there have been cases where the courts have said there's no presumption of anything. It can create a right in land, but just as with any contract, you have to construe the clause in light of the surrounding circumstances and the purpose and object of the transaction. So that's what Taleb, which is a decision of Justice Bryson, said, and the Court of Appeal has accepted that in aged care services. Aged care services. So and probably I should also show you at page 40. We've just given you some extracts from another decision, Bellissimo, which is a decision of Justice White before he was appointed to the Court of Appeal. And the relevant clause is extracted in paragraph 11, and you'll see it there in italics. Interestingly, it talks about a right to lodge, or consent to lodge a caveat. You'll see that in the second line. And then talks about, in the third last line, the creation of a caveatable interest. So it goes a little bit further than just lodging a caveat. It talks about a caveatable interest. But even in that case, you'll see from paragraph 18 that the court was unpersuaded that that language was enough to create a caveatable interest. There are other cases where similar language has been held sufficient, including a recent decision of Justice Pembroke called Talagenich, which was delivered, I was in that case, it was, I think, published a couple of weeks ago. But I suppose the takeaway, if you are drafting these things, is that you really shouldn't use this language at all because it's just too uncertain. You should just use language which would give rise to a charge or an equitable mortgage and just put it all beyond doubt. So in this case, as Michael said, the court found that Tarley did not, in fact, have a proprietary interest at all because this language was not sufficient to create an interest. And so the whole priority issue, to the extent that it was ever there, completely fell away anyway.
Also, at first instance, the proposition was put to Acting Justice Emmett, well, what's the point of that clause then? And Acting Justice Emmett said, well, you get notice. So if somebody is going to try to lodge a dealing on title, you are put on notice of it. And he said that that was some use to a lender, for instance.
Yeah, so because there's a principle, obviously, in contract law that says that every word or every clause in a contract has to have some work to do, and you would construe it in a way which gives the words some work to do. So there has to be a purpose behind provisions like that, and I suppose that's why in some of the early case law the courts were deciding that it must carry with it an implication of the grant of a right in the land itself. But yeah, Justice Emmett identified this other potential purpose for it, and so because there was nothing else that suggested a proprietary right, that's why it was decided there wasn't one. The Court of Appeal agreed, but interestingly also decided that the language itself, which you've seen about what the Aurora site was, did not actually create a right to lodge caveats on the strata title lots. And that's in fact what had happened. So as I said, there were the original development lots, then there was the consolidated title, and then the strata lots, and it was at that point that Tarley had lodged its caveats, and the Court of Appeal said effectively you never had a right to do that anyway, according to the wording in the contract. If you had any right at all, it was to lodge it on the original development lots. So what then happened is that after the judgment was handed down by Justice Emmett, orders were made, as I said earlier, requiring the property to be transferred to AJ. And Tarley wrote to us and said, would you undertake not to deal with the property pending an appeal because we might win? And we wrote back and said no. And so then instead of doing anything about that, they provided their withdrawals of caveats. They in fact consented to the orders themselves. A transfer was given to AJ and it was registered, and then they appealed. And so we said, well, apart from all the other reasons why you should lose, now also you can't win because we have indefeasibility of title. So under Section 42 of the Real Property Act, unless there's fraud, registered proprietors have title and free from all other estates and interests that aren't recorded. And of course, there's an exception for equitable interests if they have been created by the relevant registered proprietor. And that was the key issue here, because AJ had not granted any equitable interest in the property. It was the former title holder, the company, which had done that, to the extent that there was one. So Tarley argued that they had this in personam right, which somehow attached to the land through AJ's conscience, when really they should have been arguing, or the only thing they could have argued was that it attached to the conscience of the company, which is how normally it would work. But of course, it was all too late to argue that because the transfer had been registered. And normally what happens in this situation is that on settlement, there'll be a fund of money created and a lender's interests will transfer from the property into that fund, and instead of attaching to the new title that's created when the transfer is registered. But of course, sadly or otherwise for Tarley in this case, there were no proceeds because all of the money had already been paid and released and used. So ultimately, that all meant that if Tarley had an interest, then its rights had been extinguished with the registration of the transfer, and that's what the Court of Appeal held. So effectively the whole appeal was of no utility, because even if Tylee was right on its various grounds of appeal, it could never get the relief that it wanted. So in terms of preserving position pending an appeal, Michael will talk about stays, but effectively you must do something if you want to protect your position in a situation like this. One thing might be to ask for an undertaking or some kind of agreement that if an appeal is successful, then the property will be reconveyed to you as the claimant. But of course, Tylee had asked for that and we had said no. So they had another possibility of doing something, which is to obtain a stay. So Michael will just talk about that now.
So the judgment was handed down. There was consent to the orders. Tylee willingly gave withdrawals of its caveats, and there was a signed transfer eventually given to AJ, which was then registered. But in the meantime, as Josh said, we were asked for this undertaking, and we said no, and then we were counting down the days, thinking when is this transfer going to be registered? And hopefully they won't apply for a stay in the meantime. So I haven't put it up there, but there is firstly a general power to stay proceedings that the court has under Section 67 of the Civil Procedure Act. That's a very broad power. There's also Section 135 of the Civil Procedure Act, and that is more specific in that it grants the court a power to stay the enforcement of a judgment or order. We won't go into the differences between judgments or orders, because sometimes they're the same, sometimes they're not, and it's all very confusing and boring for these purposes. However, the definition of court in Section 135 is interesting, because you would think that would be the court at first instance, but it has been held that court in that circumstance can be broad enough to incorporate the Court of Appeal. Then there is the specific provision under the Uniform Civil Procedure Rules, which is Rule 51.44, sub-rule 1, which states that an application for leave or appeal does not operate as a stay or invalidate any immediate act or proceedings. So if you run off to court the next day after judgment's handed down and you file leave to appeal, or you file the appeal itself, it does not invalidate the judgment or the orders putting that judgment into practice that were handed down the day before, which is why subsection 2 is important. It says the Court of Appeal or the primary judge may order a stay. Now, in practice, what would ordinarily be suggested is that you apply in the original proceedings to the primary judge. The primary judge knows all of the issues, it knows all of the consequences of the judgment, and it can be done by way of notice of motion and supporting affidavit stating why a stay is important. Alternatively, there is an independent right to apply for a stay to the Court of Appeal. Now, importantly, that can be done straight away. You don't need to go to the primary judge first. It can also happen after a stay has been made for that very judgment. Or if you apply to the primary judge and the primary judge does not grant your stay, you can then make an independent application to the Court of Appeal after your appeal is commenced in order to stay the proceedings in at first instance. The key authority in this area is Alexander and Cambridge Credit Corp Limited. The court considered that issue of the independence of the right to grant a stay, both at first instance and at appeal, and then set out a summary of the authorities, which is quite helpful, of what considerations a court will go through both at the primary judge and the Court of Appeal as to what you need to show in order to to obtain a stay. Now, the former test was that you had to show special or exceptional circumstances. That's not the case anymore. It's more a case-by-case basis, and the court will consider things like that there is a proper basis for the stay that's fair to all parties, and also the balance of convenience and the competing rights of the parties. It ties in with the fairness point. Then the important one for the purposes of these proceedings is the risk that the appeal will be abortive or nugatory in respect of what actually happens if successful in the appeal. And that's why we have a picture of toothpaste. You can't put toothpaste back in the tube. I've tried, it's impossible. Some things can't be unwound, invalidated, set aside, or declared void. Like in this case, Section 42 is absolute, save for the exceptions that Josh enumerated, being fraud, and if there's some kind of estoppel argument you can run if there is in the equitable interest sense. So the timing is crucial. What you need to do, if a judgment is handed down and it's against your client and orders are made putting that into practice, you need to consider firstly what those orders are going to be in practice and what the consequences are going to be of those orders. For example, your equitable interest will be extinguished. That's important. Then you need to consider what the likely relief would be if you are successful on appeal. So that if, for example, you have a possibility of invalidating any step that is taken by putting those orders into practice, maybe not as important to get a stay. In the case of Section 42, absolutely crucial. So it's important that if you need to consider these things very quickly, even once judgment's handed down, make an application very quickly. You can do it by motion in the proceedings, and try and find some strong grounds, such as an irreversible effect to your client that can't be unwound. Another very strong ground is if it's a monetary judgment, for instance, and there is a risk that those funds will be dissipated, or there is a risk that of insolvency of the victorious party in the judgment at first instance. That's a very strong ground, the authorities say, as to being able to be granted a stay.
Interestingly, in this case, if the Court of Appeal had found that Tarlee did have an equitable interest, but it had been extinguished because of the registration of the transfer, then its solicitors would have been exposed to a negligence action for not applying for a stay. So they were very lucky.
They were. Which brings us on to Section 98, costs orders, conveniently. And importantly, in this context, at all relevant times in the proceedings, the company was either in voluntary administration or liquidation. And we represented 4 clients in the end, another one that didn't go to hearing. And costs were racking up, the proceedings were dragging out, and the question at the end was, well, even if we're successful, what do we do on costs? So there's a couple of considerations that you need to keep in mind, and the first is, well, how is a costs order against a company in liquidation treated? And the key provision is Section 556 of the Corporations Act, which is, it deals with the priorities of payments of creditors. And the courts have held that if costs are properly incurred in litigation by liquidators, then they can fall under various subsections of 556. So, for example, they could be considered as an expense of the liquidation and then properly paid out of the assets of the company if there are any. That still only gives you priority against other unsecured creditors. It doesn't give you priority against secured creditors, for instance. Then you need to consider the situation where costs are improperly incurred. And that's really what we're dealing with here. So the first premise is that the court is able to supervise the conduct of liquidators in proceedings, both by their conduct in the proceedings, but then by any consequential costs orders. The key case in that area is Hypec Electronics and Mead, and that's in the paper that we'll provide. Another key consideration is whether or not the plaintiffs of the proceedings are the liquidators. Now, in this case, as we discussed, the first set of proceedings were kicked off by the LUMs, so they were the plaintiffs on the face of the pleadings. But the court held that no, they were forced to bring these proceedings by virtue of the lapsing notices that were issued to them and those letters saying we'll ignore your contracts and sell the lots to other people. So the court reversed the roles and said, well, in effect, LUMs, you were defendants, you were successful in the proceedings, so it is right that you should have a costs order in your favour. You are also much more likely to obtain a costs order against liquidators if they are joined to the proceedings. So although the liquidators will be the controlling mind of the company in liquidation, who is then bringing the proceedings or defending the proceedings, if the liquidators are parties, you are much more likely to obtain a costs order. You're also much more likely to obtain a costs order if the liquidators actually commence the proceedings, so they are named as plaintiffs.
Interestingly, neither of those two things was the case in our case. They weren't the plaintiffs and they were not joined to the proceedings.
Yes, so we had to file notices of motion seeking costs orders against the third parties under Section 98 of the Civil Procedure Act. But a good practice note is if you are going to seek third-party costs orders, either against solicitors that don't do what they're supposed to, or liquidators, put them on notice very early on and say, this is not acceptable behaviour, and we will seek personal costs orders against you. The key term, though, is unreasonable, and Justice Emmett's judgment was quite good in that he set out some broad principles as to what you should look for in terms of a liquidator's conduct. So, for example, he said, if a company in liquidation is unsuccessful in such proceedings, an order for costs will generally be made against the company. However, an order for costs will not generally be made against the liquidator personally unless the liquidator acted unreasonably. So in this case, and His Honour goes on, but in this case there were two key elements of the unreasonable conduct. In the LUM case, it was the issuing of lapsing notices and forcing the LUMs to incur costs and go through the whole proceedings. In AJ's case, there weren't lapsing notices issued, but there was correspondence saying we'll ignore your contract and sell your lot to somebody else, notwithstanding that you've paid the entire purchase price. AJ, interestingly, before we got involved, also made a very substantial offer to pay the entire purchase price again for the property, $910,000. That was rejected by the liquidators. His Honour then also held that it was unreasonable to enter into the deed with Tarlee and the other financiers. There was a few different aspects to that.
You'll find this deed, by the way, at page 25 of your bundle.
So, for example, if you turn to page 33 down in the bottom right-hand corner, there is clause 2.4.
Actually, before we get there, sorry, can I just, I'll just point out to you, on page 31, at 2.1A2, these guys agreed between themselves that Tarlee had an equitable interest in everything relevant. This is the same equitable interest that the court found that it didn't have. Then there were some agreements about priorities in clause B of 2.1. Then in clause 2.2C over the page, on page 32, there were releases, sorry, C and D, there were mutual releases given, and then we get to 2.4.
But just before we get to 2.4, the thrust of the agreement was the liquidators were permitted to draw from a pool of funds that the company held from sale proceeds $1.2 million in unpaid remuneration. In exchange for that, they didn't receive the company didn't receive releases from Tarlee or Goldstone. That was crucial. So Tarlee and Goldstone could still sue the company. Tarlee was paid $2 million, notwithstanding the fact that Emmett J found that there was no equitable interest whatsoever, and they hadn't paid any funds to the company in the first place. And Goldstone, the other financier, was paid $450,000 under the deed. So you can imagine AJ's frustration when this all happened prior to the hearing.
But the liquidators themselves got a release.
Yes.
So that was very interesting.
That was. I'm glad you picked that up, Josh. Clause 2.4 then. The liquidators and the company, I should say, the liquidators caused the company to file submitting appearances in respect of every other cross-claim bar ours. In fact, Clause 2.4 required the company and the liquidators to provide all assistance that they possibly could against our client in the litigation and barred the company from filing a submitting appearance unless Tarlee gave the say-so. So you can see in those circumstances that the whole of the conduct in the proceedings was looked at, and it was found to be unreasonable, and personal cost orders were again made against the liquidators in those proceedings.
And the context was, I think, that AJ had made quite another generous offer before the final hearing, which the liquidators had also rejected. It was after they had entered into this deed.
That's right. So again, just a practice point, if you think that the liquidators are acting unreasonably, you shouldn't just think that you have a right to a cost order against a company in liquidation and that 556 will take over. In fact, you might be barred from any priority under 556 if it's found that they acted inappropriately or unreasonably. And importantly, liquidators will have some form of PI insurance sitting behind them. So put them on notice very early. Think about that insurance policy and protect your client in terms of costs at an early stage.
Are there any questions?
Yeah, Ben.
Yeah, it's a hypothetical, but if Tarlee did get a stay and AJ wasn't the registered proprietor, do you have a sense of how the appeal would have gone?
Well, we wouldn't have had the Section 42 point.
Yeah.
But the Court of Appeal determined all of the other issues anyway in our favour, so
Yeah.
I suppose it's all opened up, but yeah. So you have a question on here.
So, I mean, in this case, the liquidators went a bit rogue in how they dealt with the off-the-plan contracts of sale, but what's a lender's obligation and its position in respect of off-the-plan contracts of sale in a mortgagee in possession situation if there were off-the-plan contracts of sale entered into before the registration of their mortgage and they knew about it, particularly in construction contracts where there's often a pre-sale condition? How do they deal with contracts of sale if they enter into mortgagee in possession? They're registered first, there are no caveats on title, but they are aware of the contracts of sale. They don't want to honour them.
Well, it's really a priority issue. So once they get registration, then they're first in time.
And is there any issue with their notice of the contracts?
I don't think so, because legally, as in registered interests, have priority over equitable interests. So I mean that situation happens almost all the time.
Yeah, it's just surprising. It doesn't seem to come up any more than that. It's probably because
I think that's just because.
Trump.
Yeah.
And it's almost a matter of course in that what happened in this case is before anything had happened, and actually before I think the company was even the registered proprietor of the 4 lots before they were combined into one, the banks often require a certain percentage of pre-sales in the unregistered strata plan, and proof of that in order to show that this is going to be a successful development. So I think that would, as a matter of practice, that often happens.
Yeah.
I mean, we knew that if, this is why at the very beginning of the case, the liquidators said to the court that it shouldn't extend the caveats, because there would be no utility, because the mortgagees wouldn't be paid out and they would trump any interest that we would have.
Yep.
So if they'd been able to persuade the court about that, we wouldn't have been able to extend our caveats.
Mm. There are the purchasers' priority notices now that you can have put on title, which assist in a way. But if you're acting for a purchaser who you think has an equitable interest under a contract for the sale of land, if there's any doubt, logic caveat, you might have a registered mortgagee come along and require you to remove it for some reason, but at least in the interim there won't be any further dealings registered on title.
Yeah. Okay. Tap.
Any other questions? Thanks very much, guys.